Good morning, and thank you for joining today's call. Please note that this press conference is on the record and will be recorded. My name is Ammaha Akasa. I am the Executive Director for African Communities Together, and I will be moderating today's virtual press conference. African Communities Together is an organization for immigrants from Africa and their families. We provide direct services, conduct community organizing and leadership development, and wage campaigns to change the issues affecting our African immigrant communities. African Communities Together helped organize the plaintiffs and the lawsuit that we're going to be talking about today in today's press conference. Before we get into the substance of talking about today's press conference, a quick logistical note before we hear from our speakers. We'll be using the raise hand feature for anyone who has questions. If you are joining by phone, you can press *9 and that will raise your hand and we'll recognize and call on you. And if you are joining through the Zoom app, you can use the raise hand feature, which looks like a little hand. Just click on that button and we will recognize you. So I wanted to say a word about how we got here. So this lawsuit was brought on behalf of millions of applicants to the diversity visa program worldwide. The diversity visa program was conceived as a program to equalize access and opportunity for immigrants around the world to have a legal pathway to immigrate to the US, particularly those immigrants who don't have immediate ties of family, employment, or some other kind of fast track to becoming an American citizen. When the program has changed a great deal in the decades since its enactment, some of the earliest beneficiaries from the program were immigrants from Ireland, and while European immigrants are still a substantial part of the beneficiaries of the diversity visa program, the single largest group of beneficiaries for the diversity visa program now are immigrants from Africa, which is why my organization, African Communities Together, got involved with defending this program. Back in 2019, the Trump administration, which had been vocal about its disdain for the diversity visa program and wanting to see the program ended, erected a very substantial procedural barrier to would-be diversity visa holders, in that it required, without notice or public comment period, participants in the diversity visa lottery, that is the lottery that gives you not a visa but a chance to apply for a visa, required them to start submitting a valid passport from their country. Again, this was done brief months before the opening of the diversity visa lottery, and was a radical departure from previous practice. And we knew that this was going to profoundly affect millions of would-be diversity visa participants around the world. As in fact it did. We saw a precipitous drop in participation within 1 year of enactment of this policy. The numbers went from 14.7 million applicants worldwide down to 6.7 million applicants worldwide, an 8 million person drop. So that gives you a sense of the magnitude of this kind of below the radar screen policy change. We were in conversation with our members, their family worldwide, who were concerned about this change, who would have various obstacles to applying for the diversity visa if the passport were suddenly required, and that is how we initiated this particular piece of litigation. We were very fortunate to be put in touch with the Institute for Constitutional Advocacy and Protection, which provided the stellar legal leadership for this lawsuit, and in turn recruited Friedman Kaplan, which was phenomenal co-counsel on this lawsuit. We are thrilled by the decision Friday to vacate the passport rule and to direct the government to return to the status quo, where for the upcoming 2022 diversity visa lottery, and we're going to talk about it and talk about what it means and what it means and what it does. So without further introduction, I want to hand it over to Anil Vasanji, a litigation associate at Friedman Kaplan Seiler Adelman, to provide some information about that. Anil?
Thanks, Emma. And thank you all for joining us. We are all very excited and relieved at the court's ruling. I'd just like to provide a bit more context and explanation for the judge's ruling. As Amaha helpfully explained, the diversity visa was designed to help increase diversity of this country's immigrants, by encouraging immigration from countries with low rates of immigration to the U.S. And helping to build existing communities of immigrants from those countries. The Trump administration, fresh off very disparaging remarks about immigrants from particular places in the world, pushed through the diversity visa rule, and it skipped what is a necessary requirement of the Administrative Procedures Act, the notice and comment period, which Amaha alluded to. The notice and comment period is critical because it enables affected communities, communities in this country and elsewhere that are affected by a particular rule, to meaningfully engage in the rule, to provide them notice if they need to make changes, or if there are ways to address the concerns that the rule is designed to alleviate. In this instance, that did not occur. And as we have seen, and as Amaha indicated, and as I think we'll hear from the other panelists, the rule did obviously affect enormous populations around the world and communities within this country. Affected communities should be able to speak out and explain why or how a rule affects them. Here, they would have been able to explain that the passport rule in many parts of the world where people don't have passports would prohibit people from even participating in the program. That in many parts of the world, obtaining a passport is nearly impossible given the costs and time involved. Whereas obtaining a passport later on in the process, once you've already been accepted to the United States, is vastly easier, and how the program was designed in the first place and has operated for 25 years. That was the basis on which we challenged the rule as a violation of the Administrative Procedures Act. And the judge, we were happy to see, agreed with our position and struck down the rule. And in a very thorough ruling, and it gave a deep explanation for why that was the case. So we were relieved to see that the judge agreed with us, and the court also rejected the government's attempt to justify skipping notice and comment by relying on what it claimed to be the foreign affairs exception, which I won't go into too much detail, but is essentially arguing that because anything that touches immigration is essentially a foreign affairs function, it falls under a foreign affairs exception, and therefore notice and comment is not necessary, and rules can be promulgated as final rules. And the judge rejected that. That would essentially swallow the entire notice and comment requirement, and eviscerate any possibility of communities participating in the rulemaking process, which is what they're supposed to be allowed to do. So I will pass it along. I think we are very excited with the ruling. We are optimistic that affected communities in the United States and around the world will be able to meaningfully participate in the diversity visa process, and hopefully things will be able to get back to where they were before. Thank you very much, and we appreciate all your participation.
Thank you for those comments, Anil, and thank you for your work to produce this recent victory. We will turn next to one of the anonymous plaintiffs in this case. The plaintiffs in this case are two applicants to the diversity visa program who from Ethiopia and from Ivory Coast, and their U.S. citizen siblings. This is anonymous plaintiff AK, just a coincidence in terms of the initials being the same as mine, as you'll hear in a moment, is a sibling of a diversity visa applicant in Cote d'Ivoire, Ivory Coast, and helped bring this suit on behalf of her sibling, who has applied many times to the diversity visa program, and on behalf of her interest in reuniting her family and for her brother to have an opportunity to be a legal migrant to the U.S. So I will thank her for her participation in this suit and invite anonymous plaintiff AK to share a few words now.
Good morning, everyone. Thank you, Mr. Kassa. I would like to start by sending special thanks to African communities together and the legal team for doing such a wonderful job in winning this case, which was not an easy one. I wasn't even hoping that this will go through, but thanks God. So I'm going to start by giving you a little background on my involvement in this case. A couple years ago, I was faced with a dilemma. Raising my children alone, I needed my husband by my side, who was then living in Ivory Coast. So I decided to start the process of filing for an immigrant visa for him. At the same time, my younger brother, who I raised and is basically my son, because our father died when he was 3 years old, wanted also to come here to have a better life, because, back home, his financial situation wasn't that great. So that was one of his dreams, to come and reunite with me. Both of their cases were financially demanding. My husband, having all the necessary documentation, found this process to be easier, as his process will last 1 to 2 years. My brother, on the other hand, process, if I wanted to apply for him, will last like between 7 and 14 years. So the diversity visa lottery was, my only options to process the speed to bring him over. But, as the new rule came into effect, it would have been really, really difficult for him to apply, because even obtaining a visa back home was really a big deal. Like in my country, to obtain a visa, you need to have like a recent birth certificate, which is less than 6 months. You need to apply for a naturalization certificate, even though you were born in Ivory Coast and you are Ivorian. And you also need to prove that one of your parents is Ivorian. You need to prove their ID. And we have only one city, the capital, where people can come, and ask to have a passport done. So which means if you live like 7 hours from the city, you're going to have to travel. If you have like a job which is not even decent, you may end up losing this job. So you're going to travel, leave the job, all the expenses. And for just to apply for a diversity visa, it wasn't an easy thing, because all the burden will, almost fall on me. So to get a passport, if you need to spend money and go through all these struggles, is not things that will be like easy. My brother and us, we got really frustrated by this new rule of obtaining a passport in order to apply. So I decided, to join this lawsuit to make our case heard, because it was really, really unfair for the Trump administration to bring up this rule, and especially 1 month before the application opened. That was like crucial to me. So for me, I'm not gonna, I know I have only 2 minutes, but to close, this is a victory for my brother and myself. But what makes me extremely happy is the fact that people all over the world will benefit from this action. And I believe that this win could increase again the number of applicants for this diversity visa. Thank you.
And thank you so much to our anonymous plaintiff for that illustration of some of the ways in which our immigration system is really broken, and one of the few and most critical pathways to legal citizenship, the diversity visa. How this rule really threatened that, and as anonymous plaintiff AK pointed out, this is a ruling that's going to affect millions of people worldwide, certainly in Africa. Some of the hardest hit countries include Ghana, Ethiopia, Egypt, Sierra Leone, where applications dropped by over 90%, but not just Africa, also Nepal, Ukraine, Uzbekistan, Iran, some of the countries that saw significant drops in diversity visa applications because of some of the barriers to producing a current passport, which people face in country. So I want to turn next to Seth Wayne, from the Institute for Constitutional Advocacy and Protection. Seth is senior counsel at Icap, to share some final remarks regarding EB versus Department of State and the significance of Friday's ruling.
Thank you so much, Mr. Casa. And I just want to start out by expressing my gratitude to you and to African Communities Together, and to our anonymous plaintiff who's here on this call, and our other anonymous plaintiffs, and to Mr. Vasanji and the folks at Friedman. This was a total team effort to fight this rule, and it was all started off by ACT flagging it as something that was potentially of enormous impact, and has now shown to be of enormous troubling impact on people around the world who want to take advantage or go along with the promise that the diversity visa was intended to fulfill. So just as a quick background to Icap, we are an institute at Georgetown Law School. We use various types of legal advocacy to try and defend American constitutional rights and values, and reinforce the integrity of our government institutions. When African Communities Together came to us with this rule, which had been hastily enacted, and told us about the potential impact, we were really blown away by the damage that this rule could do specifically on particular communities, and that it had been passed without going through a public notice and comment period, which the APA requires. So we were really encouraged to get involved and try and challenge this rule. And what we found out during the course of this litigation was that the government was pushing an interpretation of their statute that essentially would have allowed any immigration rule to be made by the Trump administration and future administrations without going through public notice and comment. That in essence, the public had no input on decisions that affected immigration pursuant to their interpretation of the statute. We thought that was wrong and very troubling. Immigration to the United States has an enormous impact on communities around the world, including particularly Africa and African communities in various places there, as Mr. Casa mentioned, but also on existing communities in the United States. Diversity visa should allow communities from countries that don't send many people to the United States to have the promise of growing and reuniting with family members, like our anonymous plaintiff expressed was her interest here. So the government's rule and their interpretation of the law that allowed them to pass this rule with no public input was particularly troubling, given the enormous impact that this rule was slated to have and did in fact have. We're really pleased that the judge reaffirmed the kind of basic principle that when rules of importance, when regulations are being made that are going to affect communities around the world and communities in the United States, the public has to have a voice before those rules are passed in a way that forces the government to consider that impact. Given how hastily this rule was put into place and the scant support for it that was provided by the government during the course of this litigation, it seems that the immense impact, the millions and millions of people this affected around the world, the many people in communities in the United States that this affected was not fully taken into account before the rule was put into effect. And I think that is the important principle that was articulated by Judge Kelly in this decision. And I'm really pleased we were able to have success. And I'm glad we were able to work with these partners who were incredibly supportive and valuable. And I hope to continue this collaboration going forward. Thank you.
Thank you so much, Seth, and thank you for your work on this case. So we're going to see if we have questions from our members of the press who are present. And while we do that, though, I'm just going to ask a couple of questions of both of you. Starting with you, Anil, one of the issues at contention in this case is that the government claimed that there was adequate notice and comment because after disseminating this rule, after putting this rule in place, it offered members of the public an opportunity to comment. What was the response to that, and what did the judge have to say?
Yes, the government tried to rely on essentially claiming that it had opened up some period of comment to the public. However, that's not what is meaningful notice and comment. The rule was already final at that point. The rule was in place, and no matter what anyone said in public, no matter what comments were received, the rule was not going to change. And that flies in the face of what the notice and comment period is supposed to allow, which is meaningful engagement with the communities who are affected. So as we know, ACT and other communities did write and expressed how this rule would affect them. But of course, there is no legal obligation for the government at that point to do anything. And so, of course, they did nothing and the rule continued unabated. And the judge made that exact point, as we did in our briefing, which was that's not what the Administrative Procedures Act requires. That is not what is democratically required. And in order for the community to participate and engage in rulemaking, it has to be a meaningful engagement with the community as a collaboration, not a unilateral decision by the government that this is a rule which, as we see, has affected millions of people worldwide, done without any kind of actual engagement with the public.
Thanks, Anil. And Seth, you're with the Institute for Constitutional Advocacy and Protection. Why is notice and comment, even though it's in the Administrative Procedures Act, why is it an important constitutional protection? What's at stake in this case? What was at stake in this case beyond the millions of people who were directly affected by the diversity visa passport rule?
That's a great question. So although constitutional is in our name, we don't limit ourselves to litigation that involves directly the Constitution. What we consider to be important is to be constitutional rights and values, the greater idea that the constitutional, I think, principle of the greater idea that the public should have input in how their government works is something that really drew us to this case, and we think is immensely important. Even though this case, the legal basis for it was specifically the Administrative Procedures Act, we believe that the idea that the public should have input in the way their government functions and should be able to be heard on things that immensely affect them is something that is a foundational constitutional principle behind the way American government should work. So that was something that really drew us to this case. And I think what Anil said is really was a big flag for us. The fact that the government was arguing that notice and comment after the rule was final was sufficient, although that goes against the way the statute is written, what is required. The idea that that is enough, if the judge had agreed with that, it would have essentially eviscerated this important legal protection that limits the way the government is able to make rules and requires them to take into public consideration before they make those rules. If the judge were to buy the argument that, well, after the rule is in effect is good enough, you just have to throw a bone to the public and let them be heard, even if it makes no difference and the rule's already in place and we're not going to change anything, that would have essentially said this law is meaningless and has no effect, and the public has no voice in the way immigration rules are passed, and it would extend out to other rules throughout the government, the way the executive branch works in all sorts of different ways. If something less than what the law says is required is good enough, then the law essentially has no meaning. And that was something that we thought required us or obligated us to stand up and take a stand.
Absolutely. It's sort of the barn door exception to notice and comment, right? It's like you can close the barn door after the horse has already escaped. And notice and comment after the fact. I guess for both of you, I think on the face of it, this rule seems like it could be reasonable, necessary. Requiring people to provide a passport in order to apply to the diversity visa lottery, to then get a chance to apply for an actual diversity visa. If it's not necessary, then why is it not necessary? And if it is not reasonable, then why is it not reasonable? What were some, as you in the course of the litigation learned more about sort of the barriers to obtaining a passport internationally, particularly in some of these kind of hardest hit countries, what are some of the things that stuck out to you?
Well, from our perspective, I think it's worth bearing in mind, especially, for many people who are privileged, we take for granted sometimes that, you have a passport, it's easy to obtain, but in many parts of the world, the costs are prohibitively high to get a passport. Many people around the world, and even within the United States, do not have a passport. I think I learned that more people than not in the United States do not have a passport. The costs are prohibitively high. As I said, it can take days, for instance, especially if you live not in a major city center, you have to travel across the country, go to a passport office, stand in line. Sometimes that takes, a couple of days' wages, not to mention the transport costs. For some of our plaintiffs and some of the people that we spoke to, these are costs that, we're talking about days, weeks worth of wages in order just to obtain a passport, and in order then to simply enter the program. And I think there's a big difference between entering the program, obtaining a passport simply to enter the program, and then obtaining a passport once you have already been accepted. The latter stage, obtaining a passport, is actually much simpler in a way, because people are willing, for instance, to lend you money if they know that you're going to travel to the United States. You're willing to make certain sacrifices if you are going to immigrate to the US and join family and join your communities there. The community was willing to rally around people and help them make this next stage in their life. Those opportunities are simply not available at the early stage of entering the passport lottery, the visa lottery. So I think this is an example of a rule that sounds maybe on its face a little reasonable, but as soon as you start to peel back the layers, is actually quite unjust, and some people might argue deliberately so.
Anything to add, Seth?
I think you said it right, Anil. This is something that I think on its face would seem reasonable to people who live in places where passports are readily obtainable, but that's simply not the reality in many parts of the world. And I think what inspired ACT to get involved and then us to get involved is that it came in the wake of comments that were derisively directed towards people from certain countries and their possibility of immigrating to the United States, and this rule had a disproportionate impact on those places. So that was something that I think was really inspired us to be involved, and was hard to know because we never got the administrative record given to us in this case, was likely a potential basis for this rule. The government claimed that this rule was necessary to combat fraud, but really that was unsupported. Never in their briefing did they explain what the basis for that decision was, how that worked, what information informed that decision, and they just simply did not support it at all. There certainly does not appear to have been, or we wouldn't know if there were other efforts made to find other ways to fight fraud that would not be so impactful on folks trying to enter the program, because they simply didn't support that decision. So we're glad for the ruling, and we think that it really, the rule as it was, did not take into account the actual impact it had on folks around the globe.
Absolutely. Yeah, I think it's critical to keep in mind that what people are winning in this lottery is the chance to enter a years-long process of being vetted, at the end of which they may be granted a visa to immigrate. So it's just to require people to go through this really arduous process. And we heard from anonymous plaintiff AK that there's only one place in the whole country, the capital city, where you can apply for a passport. I know that for our Ethiopian anonymous plaintiff, EB, that it is the same case. He lives in Arba Minch, far from the capital of Addis Ababa, and so it would be a multi-day process of shutting down his business and traveling to the capital in order to get a passport, to have a distant chance of then winning the opportunity to apply for a visa. And so it's really sort of having to incur an enormous expense and difficulty. And as we heard, in some places, passports simply weren't available. There were massive backlogs, that people would only be issued a passport if they had imminent travel plans and could produce essentially a travel itinerary. We heard about some countries where new passports weren't being printed because there were shortages in the availability of the kind of secure paper needed to use on passports. And so what seems like a very reasonable thing, maybe if we're sitting in the US and we can go apply for a passport at our local post office, is a very different story as we look around the world. And that's why I think we saw such a dramatic drop off of 8 million people in the diversity visa lottery applications. So again, on behalf of some of those 8 million people, I want to thank Anil, Seth, Anonymous Plaintiff AK, the team at African Communities Together, and everyone who helped bring about this important and in some ways historic decision that took place last week. I want to thank our participants for joining us. And with that, we will conclude. We will drop some contact information for anyone who wants to, there it is in the chat. Thank you, Sydney. For anyone who wants to has follow-up questions or wants to connect afterwards. Thank you and have a great rest of your day.